Okay, so today we're going to be looking at another principle in IDEA, and that is the principle of due process. And you see on this slide it says conflict resolution, and really what we're talking about is the law has built in a system to resolve conflicts between parents and local education agencies. And so the first that we want to address is mediation. And this slide really just points to what are the sources of conflict between families and districts. And um, so there are a number of things that occur when there's conflict. And I guess the best way to picture this is that it gets to the point where um, I think the picture of the positions hardening, then everything deteriorates at that point, and mediation can be a very good thing. It may potentially avoid due process, which we'll talk about a little bit later. And so when you look at the whole due process or conflict resolution process, each state has to have a system in place that provides for more informal ways to deal with conflict, up through formal ways. And our most formal, as you'll see, will be due process hearings. So the informal ways to deal with conflict, I should say, are still confidential. There's usually no witnesses involved, or very minimal number of witnesses. Attorneys may be allowed, but they're not required, and a lot of times they're not present. Each side is working towards negotiating, compromising, lessening the hostility. There's an agreement. In mediation, there is a written agreement, and it's usually done right at the table with parties present. However, if you go to mediation, if the parties go to mediation, that does not waive the rights to seek due process. Once you start to move towards more formal processes to deal with conflict, again, may be confidential, although the parties, particularly the parents, will be asked, do you want this an open or closed hearing? They could elect it not to be confidential. There's a number of witnesses, attorneys are present. There's evidence and testimony that's presented, and the decision making is left up to a hearing officer or a judge. Usually by that point, tensions are very high, and there's a written decision by someone who has nothing at all to do with either side. Either side can appeal to a court. So formal really looks like the court of law and is the court of law. So if you looked at a comparison of, again, moving from informal to formal, you see there's costs involved. There's courts involved. When we get to formal, there's a judge involved or a hearing officer involved. At the mediation stage, there's certainly someone trained to mediate, again, and that person is an impartial facilitator. So whether you're in mediation or due process, there's a process. And in a mediation process, the mediator will really go through preliminary matters, and that as well as the opening statement will set the tone for the day, and the mediator will talk about how parties are going to proceed. Then there's allowed time for remarks by each side, and when the one side is presenting, the other side needs to be quiet. There's no discussion at this point, and then the reverse, the other side gets to present. Then there's joint discussion after that. So both sides are respectfully talking about their issues and the points. In the preliminary matters, those issues are defined, so we can't go off on tangents in mediations. So we can't go off in tangents. And then there's what's called a caucus. And a caucus is when the one side will leave the room, and so the other party gets to speak quietly with the mediator. And then the reverse happens. The other party comes in, and they will caucus with the mediator and the other parties outside waiting. And then the reconvening of parties takes place, and these steps in terms of joint discussion and caucus can happen all day if necessary, with joining in discussion and then each side getting to speak to the mediator on their own. There is a reconvening in parties, and hopefully then the issues are resolved and that results in a written agreement. A due process is, again, the most formal besides a court of law, and a hearing officer will decide on issues such as related to identification issues, evaluation, placement, and appropriate education. Sometimes there'll also be issues related to discrimination based on disability. And so the local education agency as well as the state education agency have to have procedures in place to protect children with disabilities and also to outline conflict resolution processes. In Pennsylvania, we have the state we're in, so we talk about this state. We do have a system where it's heard by a hearing officer, and then the either side can elect to go right to court, not to the appellate level review, as indicated on that slide. That's actually an older slide, I apologize. But now, at this point in Pennsylvania, it's called a one-tier system, and in the past it used to be a two-tier system. In Delaware, which is the other state that I do hearing officer work in, there's 3 hearing officers that hear. There's a panel of hearing officers, but in Pennsylvania there's 1 hearing officer. But whether you're in Pennsylvania or Delaware or in New Jersey in the Third Circuit, things are handled differently, but all hearing officers are impartial. And so there's a system in place from the state as to how hearings are requested, and to look at what your individual state, how they handle that. You would go to the state agency that's designated to handle those. And in our state, that is the Office for Dispute Resolution. Once you get to a due process hearing, it's very formal. It is like a court of law. And so each party, each side must prepare documents and witnesses. And they must provide the documents or list of documents and the list of witnesses 5 days prior to the hearing. And that's called pre-hearing disclosure of evidence. And the purpose of that is so that each side can present their case. Again, it's like a court of law, so witnesses will be called. They'll be sworn in by a court stenographer. They will have to testify, and they will have to look at evidence or documents. So the powers of the hearing officer, and that is pretty much to make a decision and to make rules, to make a ruling on the issues, and it has to be based in law, but also to essentially run the hearing like a judge. In terms of the process, in a due process hearing, there will be, again, introductions by the hearing officer, just like in a mediation, which will set the tone for the day, as well as to deal with any preliminary things, such as, are there stipulations, are there any motions each attorney wants to make, or the parents if they're representing themselves, which they are allowed to do in due process. And then each party is allowed opening statements, which again will set the tone for the day in terms of what they're trying to prove. And then each side will present their evidence and testimony. So usually the side that will go first is the side that elected to come to hearing, and they are allowed to present all of their witnesses. But the other party has the right to cross-examine each witness. At the very end, and this could take days to get through, there are closing statements from each side. The hearing officer's decision then has to be rendered within the timeline. All hearings have to be conducted within an appropriate amount of time because the child is waiting for that decision to be made. It's called the stay put provision. So the child's IEP remains in place and the placement remains in place until a decision is rendered. This is an example of a cover sheet. You can find all of Pennsylvania's hearing decisions on the Office for Dispute Resolution website. So there'll be an introduction, and then the hearing officer will identify the issues that he or she heard, usually written in the form of a question. And then there'll be findings of fact, and the finding of facts are those facts that the hearing officer pulled from the testimony and the evidence and the transcripts, because every single word said at the hearing is put into transcripts by a court stenographer. So the issues are there. And then the hearing officer will write a discussion section. And it has to be anything that is discussed has to be based on law. And the hearing officer will render an order. And that takes us through conflict resolution, the first part.